Travel. This is one of those areas that really depends very much upon the kinds of matters that are being handled, local, out-of-town combinations. If there is not a clear rule in this area, or there are too many exceptions in this area, travel can really add up. For those of you who have matters or have practiced in towns like Los Angeles, New York, Washington, D.C., Chicago, there can be times when your counsel are traveling more than they're actually in court or at a meeting. In those circumstances, you need a clear rule, and you need a good way of administering that rule. One of the things that I'm also going to say is that you need a way to develop exceptions to the rule in exceptional circumstances. Good guidelines are flexible, and they have ways of implementing exceptions without hollowing out and abandoning the rule. Out-of-town travel, there are a number of approaches to this taken by different companies. For some companies, they'll say, if you're doing substantive work while you're traveling, charge us for that, but we're not going to pay you to have dinner and watch a movie on an airplane. Others believe that there is an opportunity cost on the attorney's time when they're doing out-of-town work, and they can be charged at a half rate or some other discounted rate. And others will pay full rate under some circumstances. I believe that there is no perfect and correct answer to this. I do believe it is important to think it through. Here is one of the areas that we have seen before. Travel charges for driving to a local court blended into a block bill charge. I'm going to stop there for just a minute. And here's really something to think about here. For those of you who are either creating bills that are a block bill basis or see bills on a block bill basis, the distortion that travel makes is fairly significant. So here you have one where the travel time was 4 hours, the entire time was 4 hours long, but the court appearance was half hour. If it is a block billed entry, it's impossible to figure out which part of it was substantive work and which was not. In that circumstance, the travel time should have its own rule and should not be blocked in so that it can be adjudicated properly. Here's another one. If the counsel charging at full rate for 8 hours of travel with 1 hour of preparation and a 1 hour meeting, this is a judgment call by the client. But what I'm emphasizing here is that travel should be something that is addressed, something that's talked about, and something that's fair. One of the least fair ways that this can be done is to have no rule or no good rule. And what happens is different firms get treated different ways. That's not great for fairness, and it's not great for morale.